Thanks very much, everyone. And before I start, I just wanted to acknowledge that we're meeting in the land of the Gadigal people of the Eora Nation and pay my respects to their elders, past and present. Human rights are facing an uncertain time, both here and abroad, but I'm going to focus my comments tonight mainly on Australia because I work with the Human Rights Law Centre and we're an Australian organisation that looks at human rights issues in Australia, but also at the impact of Australian foreign policy and businesses overseas. And I think we're in uncertain times not only because of the rise of nationalism and populism, although I agree that they're really live factors, but because of the very concerted actions of Australian governments at state and national level to undermine democracy and the rule of law, in fact, the very institutions and traditions that protect our right and keep our government honest. So what I'd like to do is just talk briefly about what Australia's relationship has been to human rights and then look at some of the examples of how I see rights and the rule of law are being attacked at the moment in Australia, and then finish off with a little bit of how we might address these attacks. Australia's had a strong but uneven history of support for human rights, democracy and the rule of law. We're obviously a really stable and strong and prosperous and peaceful nation, but when we federated, our founding fathers didn't see it necessary to put a Bill of Rights in our constitution. And what we have now is a very patchwork and piecemeal legal protection of rights in Australia. But internationally, we've actually been a really strong player at times. So Australia was one of the 8 nations who actually drafted the Universal Declaration of Human Rights. And it was an Australian, it was Doc Evatt, who was President of the General Assembly and oversaw the passing of the Universal Declaration there. But as I said, our history's been inconsistent and there's been a lot of recent pretty low points, and Elaine's mentioned some of them. I think our treatment of asylum seekers and refugees, the treatment of Aboriginal people in this country, and also just seeing how our government ministers consistently flout the advice of international independent experts that Australia is actually violating international law. And that is consistently happening, particularly in regard to offshore detention. Nonetheless, Australia remains committed in word at least to being a human rights abiding country. And in fact, I looked at the DFAT Human Rights website to see what kind of image we're projecting from our Foreign Office. And it says, Australia believes the protection and promotion of human rights is every nation's responsibility. We take this responsibility seriously, including through our National Human Rights Institution, the Australian Human Rights Commission, and our Human Rights Framework. We have a strong democratic tradition, a transparent and independent judicial system, and a free media. Well, I found that very interesting because in the 4 areas that the DFAT website mentioned, the Australian Human Rights Commission, the strong democratic tradition, the independent judicial system, and a free media were all issues that I wanted to talk about tonight. I agree with DFAT that these are the hallmarks of a strong democracy and that they're extremely important for protecting our rights. But whilst DFAT tells the world that these are Australian principles and values, at home I think we see something quite different. So I want to just talk about each of these elements in turn and discuss briefly the way that I see governments in Australia undermining these institutions and traditions, and these institutions and traditions that have really made Australia, in comparative terms, a really great democracy. The Australian Human Rights Commission, I'm sure you can guess what I'm about to say, but it plays a critical role in holding our government accountable for human rights abuses. It has a legislative role to do so. But we've seen in recent years the Commission's budget being drastically reduced. That absolutely limits its ability to keep the government honest. And of course, we saw the unprecedented attacks on Gillian Triggs, the President of the Human Rights Commission, simply for reporting on the abuses that were happening to children inside immigration detention facilities. We saw the Attorney General attempt to procure her resignation, among other things, and Immigration Minister Peter Dutton called her a complete disgrace and suggested that her position couldn't continue. Far from protecting the Australian Human Rights Commission, the government sought to undermine the President, engaged in personal attacks on her, applied political pressure, and sought to undermine the President in the course of her work. And these are not the actions of a government that respects human rights and the rule of law. To its credit, the Human Rights Commission remains incredibly strong despite the attacks that it's faced. So the second element that DFAT called on in its website was Australia's strong democratic traditions. And of course, Australia does have incredibly strong democratic traditions. But what we're seeing is a really clear and worrying trend of Australian governments gradually chipping away at our democratic rights. And I'll give just two examples. The first is anti-protest laws. These laws are being passed at state level and they are eroding our ability to stand together and speak up about matters that we care about. New laws in New South Wales, here in New South Wales and also in Tasmania, are restricting people from protesting in public spaces, even peaceful protests, for a very short amount of time if it would hinder a business activity. The Tasmanian law has recently been challenged in the High Court by former Senator Bob Brown. And part of the problem with that law is that it prioritises business interests above the basic democratic rights of all of us. And I mean, it's very clear that governments can't just sell off our basic democratic rights in order to appease vested business interests. But that's exactly what this Tasmanian law does. So I think Bob Brown's challenge to this law is going to be a really interesting test for how the Australian Constitution can actually protect our basic rights to speak out on political matters and to protest in a way that might hinder a business activity.
Go, Bob.
The second attack that I wanted to mention on our democratic freedoms is something that's quite insidious but that is affecting charities and not-for-profit organisations all around this country every single day. They are facing political and financial pressure to keep quiet. And this is indirect and direct pressure. So we used to associate attacks on civil society and the silencing of civil society with authoritarian regimes, but unfortunately we're seeing more and more of it in Australia. And what I'm talking about here are things like gag clauses that government is putting in its service agreements with not-for-profit organisations. So clauses that say you cannot advocate against government policy if you take this service agreement. And also other attempts to hamstring the ability of environmental groups in particular to fundraise. So there's been a concerted effort on behalf of the federal government to remove what's known as the deductible gift recipient status. That's the ability for organisations to receive deductible gifts and absolutely essential to fundraising. But of course, a thriving democracy needs an informed public debate with a range of voices, and charities are actually the ones who are often the voice of people who are marginalised and disadvantaged in our communities. But instead, governments are making it clear to those charities that if they speak out, then they risk losing their government funding or they risk losing the ability to fundraise. Now, we know that governments find criticism of them inconvenient and even uncomfortable at times, but of course that is just all part and parcel of a healthy democracy. So instead of shutting down debate in this country and trying to silence organisations that speak out on behalf of marginalised and disadvantaged people or speak out on behalf of the environment, a democratic government should actually be facilitating that kind of discussion. And this is important, not only because those rights are important, because protest and speech are important, but because the way that we use those rights is part of how we keep government accountable as civil society. So the third DFAT factor was the transparent and independent judicial system. And of course, we do have a very strong and independent judicial system. but the judiciary and the rule of law have also been subject to unacceptable pressure and interference from the executive. I was just amazed watching the Victorian Supreme Court in action recently when 3 federal ministers decided to publicly attack the court for its leniency on sentencing terrorist offences. Because these kinds of attacks have been growing and building for a while. But it was amazing to see the way that the Victorian Supreme Court actually responded to those ministers and demanded that they attend court and show cause why they shouldn't be charged with contempt. And I think one of the comments made by the Chief Justice really nailed it for me. She said that the ministers failed to respect the doctrine of the separation of powers, they breach the principle of sub judice, and they reflect a lack of proper understanding of the importance to our democracy of the independence of the judiciary from the political arms of government. And that's something that we also need to protect, because the judiciary obviously stands as a critical check on the excesses of executive power. And human rights and our ability to enjoy them and to enforce them become increasingly more vulnerable without that institution working properly. So the final DFAT factor was the importance of a free press to human rights and democracy. And there's many things you can say about the free media in Australia, and perhaps we can talk about it in questions, but the one issue that we're really concerned about at the Human Rights Law Centre is the way that metadata collection in Australia is jeopardising the ability of journalists to keep their sources confidential. So metadata can reveal an enormous amount about our personal lives, our relationships, our habits, where we live, where we go, our social environments. And so it has huge privacy implications for all of us. And now the government has required telecommunications companies and internet service providers to retain each and every one of our metadata for 2 years, essentially creating a basket of information that can be trawled through by enforcement agencies in Australia. This has such a huge implication for the free press. Veteran journalist Laurie Oakes called metadata retention the great press freedom issue of the internet age. And the MEAA, the Journalists Union, has called it the greatest threat to press freedom in peacetime. It's an issue that can very quickly put people to sleep. It really confused the Attorney General at one stage. But it's absolutely critical that we have a free and independent press in Australia, and metadata retention is a real problem. So, just wondering what we're going to do about these issues. And one thing that we very desperately need in Australia is some structural change, something to protect us from these excesses of government. The women's marches that happened after Trump was elected were a bit of a wake-up call for me, because unlike America, where the freedom to protest is actually protected in the Bill of Rights, I'd been working on the Tasmanian anti-protest laws and knew that in parts of Australia you can actually be criminalised just for protesting. And that includes up to 2 years imprisonment, I should say. Similarly, with Trump's travel ban, we saw all of these lawyers attending the airports around the country and using the Bill of Rights as a real instrument to protect the rights of immigrants in that country. Now, recently, Theresa May, as Elaine mentioned, talked about repealing the Human Rights Act in the UK. But we don't have a Bill of Rights, and we don't have a Human Rights Act at a national level in this country. If we had a national Bill of Rights, we could actually go to the courts and ask them to adjudicate on the metadata laws, on these anti-protest laws that are popping up in different states, and we could use that act to keep government in check. And I'm certainly not saying that a Human Rights Act or a Bill of Rights is going to fix everything, and it's also obviously it's going to be a struggle to get one. So I think in the meantime, there's an incredibly important role of civil society in this country in ensuring accountability for abuses and wrongdoing. And that's why we need to be vigilant and defend the space, that diminishing space that we have to speak freely about political issues and to stand together and speak out on issues that we care about. Finally, we just have to defend the institutions that keep the government honest. And by that I mean the courts, the human rights commissions, and the free and independent press. Thank you.